Hello, my name is Kimberly Pachowiak, and I'm the Protective Order Resource Attorney for the Texas Office of Court Administration. Today we're going to talk about protective orders and TCIC reporting, the big picture, and the advocate's perspective. Now, this has been a series of webinars where my focus has been on different people involved in the justice system and to understand how important it is for protective orders to be entered into the system and how each participant has a responsibility and a role in making sure that it gets entered properly into TCIC, even if you're not the one doing the actual entry. Now, normally, when people think of Office of Court Administration, they're thinking about judges and court personnel, but a huge part of this work comes from the advocates and everything that they do every day with survivors. So I wanted to make sure that we were able to give you some extra information on some of the things that happen regarding protective orders and what you can do to help make sure that the protective orders are getting entered, because I know that you work really hard to help survivors, and we want to all make sure that their protective orders are getting enforced. Prior to coming to OCA, I was a prosecutor in San Antonio, Texas, Bexar County, for approximately 20 years doing family violence prosecution. And during that time, I found that my sometimes crazy sense of humor certainly got me through my day and helped me want to get up and do my job every day, because it certainly is not an easy topic to have to deal with on a regular basis. So, some of that sense of humor tends to leak into my presentations. So I just want to warn everybody, being the lawyer that I am, this is my disclaimer. Usually sarcasm is the biggest issue. But I wanted to let everyone know that just because I do have a sense of humor and I choose to let it help me get through everything that I need to get done, does not mean I do not care about this topic and want to share how important it is and how near and dear it is to my heart, which is why I'm here to talk to you today. Because I truly believe that if we couldn't laugh, we would all go insane. That certainly applies to my job and my previous job as a prosecutor, and I know it applies to your jobs as advocates and people who work with survivors every day. So just keep that in mind. Which is why I usually include something like this. What sort of flowers say, "I promise to obey the protective order"? And while we can laugh at this because it just seems totally ridiculous, unfortunately, it is a pretty clear example of what often happens in protective order situations. Many times it's much, much more serious than this, but even at the very least, sometimes even something this minor can be the basis for the violation of a protective order, and certainly can be the basis for batterers who want to either stalk or otherwise harass their victims. And so it's just something to kind of keep in mind, that although this is kind of funny, it certainly comes down to that there is a definite serious side to this. So when I say domestic violence, this is what many people think about. Remember this show? They are still making it. It's 25 years old. And unfortunately, many folks who don't have any experience with dealing with law enforcement situations or domestic violence situations and how that comes to the attention of law enforcement, this is kind of what they think about domestic violence. And oftentimes, you're seeing people at their very worst. Oftentimes, you can't really tell who the problem is. You can't really tell what the situation has been and what's been going on. It's just a really ugly situation, that snapshot in time. And sometimes both parties wind up getting arrested. And so that's what people tend to think about. However, it's usually more like this.
Where's dinner?
Well, I thought you'd be home a couple of hours ago, and I put everything away.
What is this? Pizza?
You had just called me. I would have known what.
Dinner ready is pizza.
Honey, please don't be so loud. Please don't. Let go of me!
Get in the kitchen!
No!
Do you want to see what hurts? That's what hurts! That's what hurts!
Oh, please. I can't. Please.
For information, call 1-800-END-ABUSE.
and that is a little bit more accurate depiction of what goes on behind closed doors. So now for a quick glance of what we are going to be talking about in this webinar today. First of all, we're going to talk a little bit about what is NCIC, TCIC, and NICS. Basically, these are all the systems that interact with each other that ultimately will help notify officers about the existence of protective orders and hopefully help stop people who should not be getting their hands on firearms from getting their hands on firearms from licensed sellers. Now, I'm going to do it. This is going to be a very quick overview. If you have more information, please feel free to contact me. I'll be happy to go over this a little bit more if you're interested, but I just think it gives a good perspective. We're also going to be talking about the types of protective orders that should be getting entered. And then we're going to do a little bit about why do we care about protective orders and their entry into TCIC. Now, I know for this particular audience, knowing about safety and accountability, the prevalence of domestic violence, the dynamics, and some of the barriers to reporting, this is not going to be anything new. However, I kind of wanted to make sure I was showing you what I am telling other people who may not be as aware of these things as you are. So this is going to be kind of a quick overview as well, certainly not as much as we can get into, but I just want to make sure that I'm giving a clear picture to everyone about these issues. We're also going to talk about the importance of entry into TCIC for the impact on potential funding streams so that we can always be able to get the funding that we need to help victims and survivors, and also how it can affect the research in this area. Then we're going to go into the process a little bit more. Who participates in that process, kind of how it varies from jurisdiction to jurisdiction, and what are the different things that those folks do. Now, we also ultimately are going to go into things to talk about how to improve this process. As we were doing a study here at OCA, we looked at the process from start to finish, and we wanted to see kind of what were some of the obstacles that people were running into in different jurisdictions, and also some of the best practices that we want to be able to share with other people. And so I'm going to be including some of the information that I think is going to be most relevant for advocates to kind of keep in mind as they're doing their jobs. And if you're looking for other information about the other roles a little bit more in depth, then you certainly can go to our website and look at some of the other webinars that are focused more for those folks as well. So first of all, what is NICS? NICS stands for the National Instant Criminal Background Check System, and it was created as part of the Brady Act in 1993 for a computerized process to provide information on whether or not someone is eligible to receive or possess or purchase a firearm. It looks at criminal, mental health, protective order, and other types of records. Criminal records, obviously felonies, also misdemeanor crimes of domestic violence, mental health adjudications and commitments, and then protective orders, different types of protective orders. And often, not always, but FBI can make follow-up requests to the police, or the prosecutors, or the courts for additional information so that they can determine whether or not someone is really prohibited from buying a firearm. Because if they have some holes in that information, it really is important for them to fill in those gaps as soon as possible. So sometimes they will actually contact the different agencies and courts to find out what they need to find out. So NICS was created in 1993, but in 2007 this happened. It was the shooting at Virginia Tech, in which there were 32 people killed and 17 were wounded. And obviously, the responsibility for this certainly lies with the person who committed this horrible crime. But it highlighted the fact that there was a big gap in some of the information that was available to NICS. And so the federal government passed the NICS Improvement Amendments Act of 2009, and it addressed specifically mental health adjudications and certain commitments and other prohibiting factors. Because the Virginia Tech shooter was able to actually purchase a firearm from a licensed seller, going through the background checks, but his particular mental health adjudication was different in that it was an order into outpatient treatment instead of inpatient treatment. And so that did not trigger the information to let everyone know that he was not eligible to have a firearm or should not have been. So they were unable to deny him the transfer of the firearms that were ultimately used in the shooting. So another what has to do with the alphabet soup, all the different acronyms for the systems that are involved in this process. First of all, and I know this is just review for most of you guys, is the Texas Crime Information Center, which is accessed via TLETs and provides responses within 12 seconds on people, whether or not they have a warrant or there's missing persons or stolen property, or if there's a protective order. And the other great thing about it is it links to the national version of this, the NCIC, so they also know about if this is someone from out of state who has a protective order or is wanted, that they can find that out if that information has been entered into the system. So then the other one is the Interstate Identification Index, which is the federal criminal history database. Then ultimately, all of this feeds into the National Instant Criminal Background Check System that checks all of those records and also the NICS index to determine if people are qualified to receive a firearm under the law. Now, moving on to a quick review of the different types of protective orders in Texas that should be getting entered into the system. First type of order is the 31 to 91 day Magistrate's Order of Emergency Protection provided for in the Code of Criminal Procedure. The next one is the 20-day Temporary Ex Parte Order under the Family Code. And then finally, the Permanent Protective Order that can be done for sexual assault, family violence, domestic violence, dating violence, stalking, trafficking, any of those types of offenses. The criminal version, arrest is required, and that's going to be the Magistrate's Order of Emergency Protection. And it can be for family violence, sexual assault, or stalking. Has to be issued before the abuser is released on bond. So they're arrested for the offense. The order is based upon the information in that offense and must happen before they are released on bond. 31 to 91 days, as we talked about. And it can be mandatory if a deadly weapon was used or if there was serious bodily injury. Now, the civil version, there is no arrest required. It is the temporary ex parte protective order is the first one. It is basically immediate relief from the judge based upon an application to the court. It is up to 20 days. And basically, when that order is issued, there's also a hearing set to happen within that 20-day period for there to be a decision made upon a permanent protective order. So in the permanent protective order, the abuser is notified to appear, and it is usually going to be issued after a hearing or an agreement. It can happen both ways. And it's usually 2 years, but it can be longer if there is serious bodily injury, and if the court finds that there are 2 prior protective orders that were violated by the abuser. So after the order is issued, what happens next? The order shall be sent to either the chief of police or to the sheriff, depends on where the victim resides. And a magistrate shall order the police to make good faith effort to notify the victim, and the clerk shall send a copy to the victim. Now, if the order prohibits that person from also going to school or a child care facility, then they shall send a copy to that school or the child care facility. Other notifications that should happen, DPS should be notified. If the order suspends a concealed handgun license, which actually is required for a magistrate's order of emergency protection, the defendant has to be notified as well, and usually that's going to happen in person. If it's a magistrate's order, obviously it will be served. If it's not a magistrate's order, if it's a regular protective order. But if it's done and for a magistrate's order of emergency protection, it can be the magistrate or their designee, which is often going to be the bailiff or the law enforcement officer, or maybe the clerk. And also can be done electronically. That was a change that was made last session. But the magistrate would have to make a separate record of service in written or electronic form to show that it was actually served. Now, why do we care so much about protective orders and whether or not they're entered into TCIC? Protective orders that cannot be verified will often not be enforced. And so you have your two main goals, safety and accountability. And if you can't enforce a protective order, then it is truly just a piece of paper. And there goes your safety and accountability goals right out the window. Now, when it comes to safety, we're talking safety of victims. First of all, they are unprotected and suffer further abuse if a protective order cannot be enforced. Sometimes a copy of a protective order may actually be taken or destroyed by the abuser. It's not at all uncommon if that abuser realizes that that victim is trying to get out, that they start destroying important items such as any type of court papers, financial records, birth certificates for the kids, anything that's going to help that victim maybe get kids re-enrolled in another school, any of that stuff. So they start destroying that type of paperwork. Sometimes they may just not have yet received a copy from the issuing court because there usually is going to be a lag time of a couple of days, at least a few hours, depending on the type of court and how they're doing it. And so sometimes they just haven't even received it. And it's that first few hours or a couple of days after a protective order is issued that can be really, really most dangerous. Now, law enforcement officers, obviously, if you're a law enforcement officer, you certainly want to know that if someone you just pulled over for a traffic violation is potentially dangerous, and a protective order is a pretty good indication that, yeah, they are capable of some dangerous behaviors. It's also good to know for that law enforcement officer is that not only is there a protective order, but maybe they are in the neighborhood of where they're not supposed to be going to violate that protective order. And certainly the safety of the community. We all know domestic violence does not stay at home. It goes to work, it goes to school, it goes to the grocery store. My husband is a police officer for one of the largest school district police departments in Texas. And the Friday before Christmas break last year, he was home for lunch. I get to work from home some days, so I was home for lunch. And we listened to several incidents that came over the radio where officers were being called to the scene because a parent was trying to come pick up kids in violation of protective orders because it was the last day before Christmas break was getting ready to happen. So it definitely happens. And so even if that's not particularly our kids are going to school with those kids. So it's always really important to make sure that officers can take action based upon these protective orders. Accountability. Anyone who knows or has children understands that if a violation goes unpunished, just like if bad behavior in your children goes unpunished, that behavior tends to get worse and tends to repeat itself. And also, it will increase the opportunity for an offender to retain or procure firearms. So that's always the danger as well. So not only does bad behavior get worse, then they are able to kind of get some of the tools that actually makes their bad behavior even that much more worse and much more dangerous. But the question always comes up, do protective orders actually provide safety? I mean, we've all heard, well, a protective order is just a piece of paper. And yes, last time I checked, protective orders not bulletproof. They are not made of Kevlar. However, it's the enforceability that makes all the difference. At the Carsey Institute at the University of New Hampshire a few years ago, they actually did a study on this, and this is the link online to the report if you would like to see it. What they figured out was for about half of the victims, a protective order stopped the violence. Now, that is not to say that it was just the protective order necessarily, but in cases where there was a protective order, the violence stopped in half of the cases. It might have also been because if someone is getting a protective order, they're probably doing other things to try and keep themselves safer, doing safety planning, pursuing, change of address, different types of things. And then for the other half, the violence was significantly reduced, even though it didn't stop. But as usual, there are some caveats. The big weakness is enforcement, especially in rural areas, although I know that enforcement is an issue pretty much in all areas to a certain degree. Um, Obviously, if there's fewer resources, if your closest shelter or victim services location is 3 counties away. That's going to make it harder. Local politics is always an issue. It seems like there's usually somebody in power in an area, potentially rural, that either knows someone or is affiliated with someone who is a troublemaker, and that troublemaker tends to not be held as accountable sometimes because of who they may know in the system or be related to in the system. And last, and this one certainly is not just in rural areas, but sometimes law enforcement has either difficulties or reluctance in determining whether or not there is a predominant aggressor in the situation. Sometimes it's easier just to arrest everybody and let the court sort it out, which we all know, the prosecutors in the court, if a determination is not made usually at the scene, it's really, really tough to make that determination later on by someone else who was not at the scene. And so that's why it's so important for law enforcement to make those determinations and to ask those questions to try and get that done. Because we've all kind of seen this situation. And then next thing you know, everybody's getting arrested, even though obviously there's someone here who's a little bit more dangerous than the other one.
Looks like Elliot's gone pinned.
So, an important thing for everyone to kind of keep in mind when it comes to family violence is that no relationship goes from happy, healthy, and functional to murder suicide overnight. There is always a pattern of abuse. Whether or not anyone else knows about that pattern is one thing. Whether or not authorities are contacted or whether or not someone seeks a protective order, the police are called, but there is always a pattern of abuse. And when you speak to victims of domestic violence who've been going through it for a while, they will usually talk about that things went on long, long, long before they ever told anyone else. And it usually starts very small. While thankfully not every domestic violence incident winds up as murder, suicide, or murder, almost every, I would say every murder, suicide involving domestic violence always started with something small, way, way small. Maybe a long time ago, maybe months ago, maybe years ago, but then it tends to escalate over time. So there's a couple of different patterns. The first one is the fact that there are always actions, physical, sexual, emotional, economic, and psychological, that are used to gain or maintain power over an intimate partner. And these first these first two, the physical and sexual, those are things that potentially can be addressed by the civil and criminal justice system. However, it's the last three, the emotional, economic, and psychological abuse, that tends to really hold that victim in that situation a lot longer, in spite of the physical and sexual abuse that's going on. And so there's something called the power and control wheel, which is a very handy tool that has been around for many, many years, probably going on to about 4 decades now. It was kind of first looked at and put into practice in Minnesota, and it's based upon conversations with victims of domestic violence. And what they found based upon these conversations, and we're talking hundreds and hundreds of people that they spoke to, that there was a very discernible pattern, that there were certain things that almost always, not always, but almost always, were present in this power and control relationship. And that is using intimidation, emotional abuse, isolation, the concept of minimizing, denying, and blaming. And lots of times it's not just the batterer who's doing that, but also sometimes the victim is minimizing and denying what's going on. Children, using children as kind of a weapon, making victims feel guilty for some reason, using them to relay messages if that couple is no longer together, threatening to take children away, using male privilege, using economic abuse, and preventing her from getting a job. Maybe she doesn't know any information about any of the family finances, and always, coercion and threats. And usually there's different types of coercion and threats, usually threats of violence, but not always. Sometimes it's threatening that to make her do illegal things, threatening to report to welfare, threatening to commit suicide. All of those things all have a way of making that victim do what they want them to do. And generally, batterers only use as much force as necessary. And then once that amount of force is not doing the job anymore, then that's when they start ramping it up. Another pattern that tends to emerge is the concept of continuum of violence. And as we discussed earlier, bad behavior tends to get repeated and it tends to get worse. Well, it's the same with this type of pattern. When it comes to the verbal and emotional part of that, it will often start as name calling and maybe escalate to yelling. Now, I will tell you, and I'm sure this is not a surprise, victims of domestic violence will put up with a lot of things that happen behind closed doors for a long time. And this is certainly one of the big ones. And it may tend to escalate, but as long as it remains behind closed doors, then oftentimes they're willing to put up with a lot of that stuff in order to make sure that there's a roof over their children's head and that kind of stuff. However, once it tends to escalate into public humiliation, then sometimes that is a clue for victims and a red flag for victims that it's maybe time to do something about it. Because what that tends to tell victims of domestic violence is that this person, the abuser, really doesn't care what other people think about him, which is kind of different, especially at the beginning, because usually batterers go out of their way to make sure that the rest of the world thinks they're nice and reasonable and charming and all of that. However, once it gets to the point where they don't care about that, then for them, the situation is getting more dangerous, and they are correct in that. The next type of this is physical violence. And again, tends to escalate. Might start small, might start as a push, which in Texas would be a true Class C level offense. No injury, and no jail time. But it certainly is something that is offensive and scary. Might escalate to punching and may stay there for a while, or might just happen once. Again, as much force as that abuser feels necessary to get the job done, and can escalate up to kill. And then finally, sexual. It may start with objectification, which, you know, society tends to think of as relatively harmless as a whole, certainly not everybody, but in general, objectification is an obnoxious behavior that most people are think is harmless, but then it tends to escalate. And I had many cases when I was prosecuting, especially when I was prosecuting the low-level misdemeanor cases, where there would be visitation with the children, and so abuser would show up at the house to drop off kids or pick up kids, and when if the kids weren't right around right then, they used that opportunity to push that victim up against the wall and begin groping. And it was to send that message that we may not still be together, but I can still do whatever I want to you. And so when those things are happening, again, that's an escalation of the sexual type of contact, and then all the way up to forced sex. Lethality is another part of this equation. We're looking at the pattern of what has happened in the past to see, okay, what might be happening in the future. And this is certainly important when it comes to anyone that has anything to do with intervention and prevention in domestic violence cases. And certainly for judges as well who are making determinations regarding, do I need to do a protective order here? What kind of indicators do I have that show me that this is a situation that is getting more dangerous? And there are a couple of different risk factors, but a couple of the biggies. Um, First is prior family violence. In 72% of domestic violence homicides in this country, there was prior reported family violence that occurred. And even more startling would be 76% of female domestic violence homicide victims were actually stalked by the intimate partner that ultimately killed them within a year. So, anytime we are seeing that, it is certainly something that we need to keep an eye on and seeing what's going on. Other important factors that can help forecast whether or not this is a dangerous situation that may lead to a domestic violence homicide include threats, increases the chances by almost 15 times. The use or exhibition of a weapon during the incident increases it by up to 20 times. Strangulation, up to 9 times. Forced sex, almost 8 times. And extreme jealousy, 9 times. So these are all things that officers should be encouraged to include in their police reports about prior incidents, things that have happened in the past, because they are all things that can help give a better picture about what may be to come. Domestic violence in Texas. There are several different types of statistical measures for this, but just really quickly, some of the basic information. 32% of all Texans have experienced domestic violence. This was a study that was done in 2011 at UT. And it asked specifically, have you experienced it? Not did you commit domestic violence, or were you a victim of domestic violence, or were you defending yourself in a domestic violence situation? Just have you experienced it? That's 32% of all Texans, so about 1 in 3. If you're female, 38% of females, and 27% of males. In 2013, there were 119 women killed by intimate partners, along with 17 bystanders, and 5 of those bystanders were the children of the women that were killed. And in 2013, also according to DPS, there were over 185,000 reported domestic violence incidents. Now let's keep in mind that is reported. 97% of them were assaults, and of those assaults, 74% were deemed to be simple assaults. And those are going to be the type of assaults that would be a Class C level type of misdemeanor here in Texas, little to no injury, which is usually the kind of the ground floor type of incidents that begin a cycle of domestic violence. And when it comes to injuries, pretty much the same kind of picture. No injury, 42% of those assaults. Minor injury, 53% of those assaults. And then major injuries, which would be felony level injuries, which would be your serious bodily injury cases, only about 5%. Something to keep in mind about injuries, though, is that experienced batterers do know how to hit without leaving any immediate or subsequent visible injuries. And so oftentimes in police reports, it might say minor redness, a little bit of a scratch, or something like that. However, many batterers, they know to hit in the soft tissue areas or sometimes in the head, so that you don't have any obvious injuries, especially up front. And what looks minor can often change over the next few days. For example, what can look like this today, obviously this is a bite mark, and yes, you can certainly see it. It is certainly an injury. It can look like this tomorrow. Also, what might look like a regular minor grabbing incident, which is usually a relatively common Class C misdemeanor type of injury, might look like this tomorrow. So, which is why, as Casey Gwynn would say, we must make misdemeanors matter. We must realize that true success is not prosecuting a murderer, but is preventing the murder. The more we can focus on those low-level injury cases, we might be able to stop it from escalating to the point where we have a murder or a murder-suicide. So trying to focus on those as our prosecution efforts and our intervention efforts and our law enforcement efforts certainly would help to do that. So when it comes to reporting, we certainly have to talk about how much actually gets reported. Actually, unreported by victims about 15% of the time. Reported by a third party maybe about 8% of the time, leaving us with a whopping 76.9% of cases that go unreported. And there's all kind of reasons for this. Some of this we've already talked about. We've talked about the level of injury. We've talked about all of the mental and emotional things and all the power and control aspect of this that might or often do stop victims from reporting incidents. Other reasons that it's too minor. They feel it's too minor. They feel that they would be too embarrassed for anybody to know. That goes along with that. Many victims think that this is their fault in some way. Obviously, fear of reprisal, and often that the police cannot do anything, which is sometimes many victims think that unless you're bleeding on the floor, it really doesn't count as a crime, which is not at all uncommon. And a lot of society, unfortunately, seems to think that as well. And many just think they're not going to be believed. But another aspect of this, or one of the other aspects of this, is there are a lot of reasons and barriers that are kind of put up by the systems themselves. Example, in the criminal justice system, we already know that few victims report. And that's because there's complicated statutes that often do not reflect the reality of family violence. So then that will lead to fewer arrests and fewer reports that get sent to the prosecutor's offices. So then ultimately there are fewer charges filed. Of those charges that get filed and actually go to court, often there are fact finders who do not understand the dynamics or choose not to believe them, and so don't convict on the cases that are presented. So then you wind up with fewer convictions. Victims certainly then get the feeling that they are not safe and that the offenders are not going to be held accountable, so that's why they don't report. In the civil justice system, it is quite similar. Again, victims do not trust the system. They fear disbelief. Again, a lot of this applies also on the criminal side. Often there is a lack of objective evidence, or they don't present well. The victims don't present well in court. And while it would be really nice if we had video evidence, such as that in an elevator in a casino in Atlantic City last year, certainly that is not the case, and most batterers are smart enough to do it with no witnesses. So then protective orders may get denied, or batterers may get custody or unsupervised visitation because there's not enough evidence. And unfortunately, batterers that seek custody often get custody, even though there is evidence to the abuse. Then victims may respond in ways that they feel is going to protect themselves and their children that may not be in compliance with court orders. So then they understand that they don't really have the legal protection, or they understand that they're going to be punished for not following court orders. So again, they don't feel safe, and offenders are not held accountable. So they're not going to access the system. And of course, these barriers and the barriers from the power and control wheel that we talked about are on top of other barriers that we know exist, such as religious, cultural, those types of things. So all of these work together to make us remember that, victims may have a whole lot of really good reasons to not want to participate in prosecutions or participate in the justice system. And so it's up to us to kind of help make that easier. So moving on, why do we care about protective orders and TCIC when it comes to federal funding? Well, federal funding is often predicated on certain conditions that exist in the states or the people who receive the funding. And the NICS system requires that states report all of the Brady disqualifiers, and those are some of the things we talked about earlier. The felony convictions, misdemeanor convictions of domestic violence, mental health commitments, and protective orders. Now, if we cannot show that we are getting all of these entered properly, it can actually hamper our ability or our eligibility to get funding, and we're always looking for more funding to try and help more people and do our jobs better. Um, so if in compliance, a state may be eligible to receive a waiver of the 10% cash match that's required in certain federal grants. And if you've ever written a grant, and if so, I'm sorry, but you understand that being able to have that waiver is a really good thing to have. It's nice not to have to worry about their cash match. And also, if we're not in compliance, there are burn justice assistance grants, which fund projects at the state and local level that have to do with criminal justice. If we are not in compliance, then we may have a reduction in what's available to the state. And just an example, in 2013, the Office of the Governor received over $21 million from burn grant funds. And so, again, it's really important for us to try and make sure that we are getting everything that we possibly can and all the type of funding that will help us do what we need to do. So, and then finally, research. Research the concept of garbage in, garbage out. If we don't have good information that's going into the databases, it's really hard to extract kind of the cumulative information or the overall picture of what is going on. And if we don't have a really good picture of what's going on, it makes it much, much harder to identify the areas of need as far as sending resources, not just money resources, but also people resources, education, training, any type of facilitation when it comes to community organizing or anything like that. It is certainly a good idea to know what that need is and where we can improve. So, knowing that, based upon a couple of years of going around and doing some training and talking to various people about protective orders, it kind of became obvious that not all protective orders are making it into the system. And so we sought funding from the DOJ so that we could look at the reporting process from start to finish. Who was involved? What were the processes? What were some of the procedures, the forms, from the application stage all the way to when it gets entered into the system, and every stage in between, so that we could try to increase the reporting of the orders. So we met with law enforcement, judicial, and court clerk training organizations, other organizations that have anything to do with this, criminal justice users, DPS. We also conducted case studies in 8 different jurisdictions across the state, and we tried to do rural, suburban, urban, and also geographically, we tried to go all over the place. We went down on the coast, we were up in the Panhandle, we did East Texas, we did South Texas. We also did a statewide survey, and those of you who may have participated, thank you so much. We certainly appreciated getting the information. We actually had about 850 completed surveys, which I was really surprised, and we got a lot of good information. And so we also created a task force to help develop recommendations based upon all the information that we gleaned from these discussions. And so, what came out of that, one of the things is to develop training to improve the reporting rates, and that's part of these trainings here. I go around the state, do lots of training for various organizations, and we already have 3 webinars that are on the website, and this one is going to be going on here shortly, and we're hopefully going to do one more pretty soon. So then that way we can make this training available to let folks know kind of what are some of the things that they can be doing to increase their chances of making sure protective orders are getting entered into the system properly. And just as an example, we have 254 counties, as we know. The counties in white are the only counties that we did not hear from at least one person in that county about the process in their jurisdiction. And that's only about 12 counties, if I remember correctly. And so everybody else, we at least heard from somebody, and in many counties, several somebodies with several different roles in the process. So I was very pleased that we got such good feedback. So, that being said, how many participants are in this process? How many cooks are in this particular kitchen? Who has the information? Who has the paperwork or does the documentation? Or maybe both. Maybe this person has something to do with both aspects of that. And let me tell you, it's quite a few people. When it comes to magistrate's orders of emergency protection, and remember those are the ones that are issued by a magistrate at the time of arrest, but before release from custody. We have the victim. We have an officer, and because there is an arrest, we're going to always have an officer in these. We might have an advocate. Some jurisdictions have an advocate or an attorney that might have some role in gathering their information or contacting victims, or both. And then it gets sent to the court clerk. Whoops. Then it goes to the judge, the magistrate. Then it goes back to that court clerk. Then it goes to the district or county clerk in some jurisdictions. Some of the jurisdictions want their district or county clerk's offices or the offices want to have that so they have a record of it as well. Um, and then it will go to the police department. And sometimes in the police department, just like in any of these other areas, but often in the police department, it may go 4 or 5 different places within that department before it actually lands on the desk of the person who is going to be doing the data entry. And then to the data entry person. And then for protective orders, it is potentially even worse as far as the number of people involved. It goes from the victim, sometimes to an officer, sometimes not, because there's no requirement that in order to get a protective order, there has to be a police report. There might be an advocate or an attorney. Then it will usually go to the county or district clerk's office, then to the clerk in the particular court, then to the judge, then back to that clerk in the court, then back to the county clerk's office, then over to the law enforcement, and again may go 3 or 4 or 5 different places within that agency before it lands on the data entry clerk's desk. So that's a lot of different ways that this can go crossways. And speaking of a lot of different ways, we have such a decentralized court and law enforcement system in Texas. As we talked about, we have 254 counties, 458 district courts, 510 county level courts, 817 justice courts, and 926 municipal courts. And in those courts, there's about 1,288 judges. So, again, a whole lot of different ways this can go crossways. And then, of course, law enforcement agencies. And everybody does it differently, or most people do, at least to a certain degree. One of the other big obstacles is that they may not even be getting data sheets, TCIC data entry sheets, accompanying the protective orders when the data entry person receives it. If they do, a lot of times they're incomplete. Many times participants are not even aware of the roles of the other people in the process. So it makes it really hard to understand what they need from you and what you may need from them. And they don't know what to give you. Other common problems. Lack of regular communication, not only between different agencies, but within agencies. Lack of standard forms and orders. And like we said, a lot of folks, they do it their own way. There's a lot of suggested forms and orders out there, but everybody seems to tweak it depending on what their particular needs are. Confirmation procedure that the order was actually received by law enforcement. Sometimes there is one, sometimes there is not. I've been encouraging courts and clerks' offices to have a process and a way to have that confirmed with an actual live person at the law enforcement agency so that it is initialed and sent back in some kind of a documented form so that they know that it was received. If there is no such thing in your jurisdiction and you are part of the law enforcement agency, if you want to have something that you send back, I would highly encourage that as well. Sometimes there's lack of personnel to assist the victim or petitioner with the application. Some jurisdictions have lots of people that can help. Other jurisdictions have nobody that can help. And so sometimes that form just gets sent or given directly to the victim and they have to fill it out. Anybody who's seen this form, that even if you're in this system and work with it a lot, it's not an easy form to fill out. So there's a lot of things that may wind up on that form that are inaccurate or inappropriate or maybe not even part of what was actually ordered by the court. Insufficient police investigation, documentation, and enforcement. We've all seen that. It certainly is not majority of the time, but it's enough that it's something we all need to be concerned with. Typographical errors during data entry. Many jurisdictions have a process in place. Sometimes it's somebody else on that same shift who comes and looks at what someone just entered into the TCI system to make sure it's accurate. Sometimes someone on the next shift checks it. Either way, I would suggest you have some kind of a cross-reference way to do that. Other common problems that were mentioned was the fact that there are private attorneys that are unaware of the process and the importance of complete and accurate TCIC forms. It seems there is a bit of a disconnect when you have private attorneys. I'm not talking about the DA's offices necessarily or the attorneys that are affiliated with shelters or legal aid, but private attorneys that just do protective orders as part of their regular family law practice, unless they do it all the time, they don't always understand how important it is to make sure that all that information is given, and that basically if it's not given and not given properly, then that may mean that the order that they work so hard to get for their client is not going to be enforced. So sometimes that becomes an issue. Staff turnover was mentioned, especially law enforcement. Sometimes there was confusion regarding the applicant's address, and that became an issue for the data entry people in the law enforcement agencies, especially if there was an accuracy problem or if it was undisclosed. Now, confidentiality, very important, we all know that, but sometimes it's a matter of confidential from the respondent or the batterer is not necessarily confidential from everyone, because law enforcement does need to know a certain amount of information in order to properly enforce that order. So that became an issue as well. The problem is if an agency doesn't know where that victim lives, then they may not know that they should be the ones entering it into the system. So, handling extensions of orders after there were violations, incarcerations, or modifications, all of those things means that the law enforcement agency needs to go back into TCIC and make those changes, change those expiration dates, things like that. And sometimes they're just not getting notified about those. So if you're aware, as an advocate, if you're aware of that happening, or maybe you have worked with the attorney or the court or the DA's office or whatever to get that done, make sure that you are getting the information to the clerk's office and reminding them to please let the law enforcement agency know. Some other point of entry problems: failure or delay of receiving the order. Some of the law enforcement agencies said that they didn't get them with every order. Or they didn't get the order, or they didn't get all the paperwork, including the data entry form. Or it was a long time before they got the order. Sometimes they would get a stack of them, and you could tell that it was sent to them from the clerk's office, but you could tell that maybe it was a big stack that they waited till they had a big enough stack to send, and some of those orders were 3 weeks old, and some of them were from yesterday. So that was an issue as well. Timely notification when there's an extension or modification. Talked about that. Conflicting information between the order and the data sheet. I would certainly encourage you, when you are working with victims on these cases, and if you're working with the attorney in the courts pretty closely, to do what you can to make sure that those orders and those data sheets match. Because if they don't match, it slows down being able to get everything entered, because that data entry person really has to make decisions about what needs to happen. And if what's in the order isn't correct, and it doesn't match with what's in the data sheet, then it slows everything down, because they have to go back and verify things. Some confusion regarding out-of-state orders, who validates those, who modifies those. Again, really important for the enforcement of out-of-state orders, full faith and credit. And so sometimes they're having to work on those things as well. From an advocate's perspective, there were some definite challenges that were mentioned to us, that some of the same things: lack of communication, the private attorney situation, unable to verify temporary ex parte orders, and we're hoping that that can get clarified a little bit more. Sometimes they were able to do it, sometimes they were not. Sometimes even after they knew that the respondent was served, they were still unable to verify those things. Turnover piece was another thing that was mentioned by advocates. Now, some of the recommendations from advocates, which I really love this first one, and this is something we think we want to kind of explore to see how we can make that work if possible, is the creation of a portal similar to the child support portal, to enable the victim attorney or others to see what information is out there. Instituting the same procedure across the state for filing and entering TCIC information. Uniform mandatory forms. This was mentioned by almost everybody that we spoke to. Wanting to have training for all participants, including information on dynamics and the importance of protective orders. So that's one of the reasons we're doing this training. The clerk mandates, especially instituting a deadline for them to send it to law enforcement a certain amount of time after the order is issued. and requiring the filing of the data entry sheet up front, like it's a civil case information sheet. Being able to have that up front means that's more people along the way who can look at it, confirm it, verify that information, and adjust it if necessary. And finally, requiring entry of ex parte orders after proof of service. Some of the big picture recommendations that came along, mandatory forms, again, training, we talked about that. Potential legislative changes. These were some of the recommendations that were made to us and that we've actually been able to put into a bill that has now passed both houses of the legislature, which we hope is going to get all taken care of here. We're nearing the end of May. The deadline, mandatory entry of magistrate's orders of emergency protection. MOAPs are actually the most common type of order in Texas, and so it's really strange that it's not mandated under the law like regular protective orders. So that's one of the changes that we were able to put into this bill, and it looks like it's passed, so hopefully we'll be able to get started on that. Clarifying which agency should enter the order if they don't know the current address of the victim. One of the recommendations that was made that we put into the bill was if you don't know the current one, how about the victim's last known address? So that way, usually you're going to know one or the other. So hopefully that's going to stop that kind of bouncing back and forth between agencies saying, nope, this is yours to order. Nope, this is yours to order. So that's the goal. And then the statewide requirement to have it done at the time of the application or request. And here's that data entry form. If you haven't seen it before, there it is. And there at the very bottom is the link that if you want to get a copy of it, that is a link to where it is on our website. And you can have a copy for yourself so you know exactly what it looks like. If it's not part of your packet, I would encourage you to make sure you incorporate it into your packet as you're interviewing your clients. So then that way you can make sure you're covering everything that you need to cover that needs to go into that information. Keep in mind that all items in uppercase letters must be answered to allow entry into TCIC. That form has a lot of questions on it, and I would encourage you to fill them out as much as you possibly can. But at least everything in uppercase letters must be on that form so that it can get entered into TCIC. Even if you get more information later, at least that initial form, if it has everything in uppercase letters, then it can be entered and then modified at a later time as more information comes to your attention. Reminding the client that more information on the form increases enforceability of the order. And I know this is certainly a frustration aspect for clients and for us because it seems like, poor thing, we're just always hammering them for more information, more information. And I get it. However, they need to understand that having as much information as possible is going to help increase that enforceability. And having a protective order doesn't help, as we talked about, unless it can be enforced. Assisting the client with a form. Again, I know this is generally not going to be an issue with advocates, but any chance that you have to help the client with a form, or you fill it out, you ask the questions and you fill it out, so then you can make sure that it's all done the way it needs to be done. That will make things easier as well. And if you're completing the form before the order is issued, make sure you don't fill in the conditions of the protective order. It's not a wish list like what we would like for it to include. It's ultimately what is going to go to law enforcement after the order has been done, and it needs to show what has actually been ordered. So just leave that there until after the order is completed, and then make sure it matches what was done in the order. Other best practices for advocates. If you don't already have a written detailed protocol, please have one on how you do this. Prioritizing the protective order processing. Backup personnel, again, not really an issue for advocates' offices, but just in case. Distribute that information, that form, as early as possible, even if you're going to wind up helping them fill it out. Make sure you give them a copy so that they can be looking at it to see what information they may need to gather. And confirming the data sheet information every chance you get, every time you talk to that person, to see if there's been any change. As we know, victims in these cases tend to be transitory, and that they may be having to stay one place and they may need to move, or maybe they're just in between places. Just make sure you're checking all of that. And then revising your internal procedures to reduce the number of participants who actually touch this paperwork. The less people having to touch it in your agency, the quicker it's going to move through your agency usually. And then checking with your legal advisor about confidentiality concerns, always a good idea. You want to make sure that you're protecting victims and you're making sure that you're keeping things confidential. But let's keep in mind who we need to keep things confidential from and who really needs to know the information, which usually is going to be law enforcement. Some more best practices for advocates. I would suggest that after you get everything to the clerk's office, and then once it should have already been taken care of and done, see if they can give you a copy of the proof that the order and data sheet were received by the law enforcement agency, so that way you can complete your file. The more that information is kind of across all the agencies involved, the more we can track it down if there's a problem somewhere. Comparing the data sheet to the protective order to ensure all the information matches. We already talked about that. If you catch something, it's best to catch it before it gets over to law enforcement, then afterward. Improving communication among agencies. I would encourage you, as much as you possibly can, reach out to your agencies, your law enforcement, your courts, your prosecutors' offices, anything that you can do to talk to them. Invite them to your agency meetings, or if you have a coalition meeting or you have a quarterly meeting, that maybe make this one of your topics. So then that way they understand what you do and you can understand a little bit more about what they do, and you can streamline that process. The jurisdictions that we spoke to that actually made sure they took this step, very happy with how that turned out, and they're really happy with the improvements that were made because of it. Share your contact list. Sometimes they just don't know who to call. Ask them for their contact list. It's so nice if you have a list of phone numbers in the law enforcement or phone numbers over at the DA's office, that if you have a question or a concern, or at the court, of who you can call, who you can email to get to get the information you need, and to share whatever information you may have. Meet for breakfast. Always good to do it over food. People tend to be happier when you're feeding them. In San Antonio, that is, breakfast tacos, but whatever is good in your area, certainly encourage it. And part of this is, when you're having that communication, is finding out that full process for your agency, not just what it is, I'm sorry, in your jurisdiction, not just what it is in your agency. It's really important to make sure that you understand it, so you know where to help out and where you need to ask for help. Checking that law enforcement is receiving all the orders. If you can, when you're doing your paperwork, do a checklist on the front or a cover sheet to send with everything, so that other folks can check it off and say, yes, we've done this, that, and this, and that. Keep a copy of everything. Requiring the confirmation by an actual human. This is kind of more along the lines of for the clerk's offices, but I want to let you know we're asking them to look into possibility of, okay, not just getting the little fact sheet that says okay, but actually a sheet that gets sent to them, to the agency, law enforcement agency, and gets sent back with someone's name and phone number would be great, and date of when it was actually received and time, which would be fantastic. And then working with your contacts in law enforcement. We all have contacts in law enforcement. The more we can keep those contacts going, the more chances we have to contact them and say, hey, can I check and see if that protective order actually made it into the system? And if they can share with you any kind of proof that yes, it was in the system, that would be wonderful. So, you don't ask, you don't get. Always ask if you can. Always follow up and assume nothing. The great majority of everybody has good intentions about what needs to happen, on these cases especially. However, there's always things that happen. Assume nothing. Just, if you make it part of your regular business to follow up, then you're not making it look like, hey, I think you did a bad job. It's like, hey, we just need to make sure that our records are complete and that we know that things are done, because we have victims who contact us and want to know what's going on. So anytime that you can do that, I always encourage it. I know you know this, but just as a reminder, protective orders are definitely really important piece of the domestic violence homicide prevention puzzle. Um, and as I stated earlier, advocates are kind of where the rubber meets the road here. It's you guys that make sure the rest of us are trying to stay on top of what we need to stay on top of, and you are always the mouthpiece for victims. So the more information that you can share with us, and the more information you can get from us, is always a very good thing. And we really appreciate the hard work that you do. I know that it is often a thankless job, but anything that you can do to help us do the best we can is greatly, greatly appreciated. That being said, if anybody has any questions or concerns or suggestions, please feel free to contact me. Here is my information, 512-936-6390. And my email address, my phone number goes directly, to my cell phone. So if you need to reach me, that's the best way to do it because I'm on the road an awful lot. Same with email. I check my email all the time. So I'm not in the office very often. So it's usually the best way to do it. And also the website for Office of Court Administration is www.txcourts.gov. And if you go ahead and go to that website under programs, click on that. You'll see listed under their domestic violence resource program. Go ahead and click on that, and you'll see my page. It has some other webinars, like I said, that are kind of directed toward other participants in this process, some other information. I'm always trying to add to it, and I'm going to continue doing that. But anything that I can do for you, please feel free to contact me. Thank you so much.